Good afternoon, everybody. Hello, Alex. Hi, Erica. Hi, Felicia. Hi, Amelia, Sharina, Heidi, Christy, Valeria. It's great to see a couple of familiar faces. We'll get started in like one more minute. Y'all know I like to start like 5 minutes after. Alex, I'll give you controls should we need them just in case. How's everybody doing? Let's see, last week of, hi Ever. Last week of October, like where the hell did October go?
Where did this year go?
Yo, that too, because I remember like Amber, we were just talking about Q1. Yeah, now it's Q4. This is wild. Okay, so before we really dive in, anybody have any milestones, wins, accomplishments, any like good feel good stuff that anybody want to share? Let me hear at least a good milestone. Ooh, Heidi, yes.
Well, I'm the co-founder of Constellation Farms in Springville, California. We're between Visalia and Bakersfield in the mountains. And we've just begun our program, soft opening of about 2 weeks. And we provide services to people with developmental disabilities with a farming and art focus. And we've written for several grants, and it's always been ding, ding, ding. And we finally got our first win, a $15,000.
Oh my God.
Yeah, $15,000 farming new producer grant. All the reasons why we were getting dinged before, which was because we were new. This one focused on being new. So we'll be using those funds to purchase and grow 300 plus blueberry bushes, and for our individuals to be able to tender and turn into a U-pick farm.
Wow. Sounds like you've got to take a field trip up to the Visalia area.
Yeah.
Congratulations.
So that was a big deal for us. And just starting our program, having a booth at our major apple festival in town, that was a big deal. So like everything kind of culminated at once.
Yeah, that's awesome. I love it. Congratulations.
Thank you.
That's a huge win.
Thank you.
Yeah. Anybody else have any wins, accomplishments, milestones to share?
I'll share that we won. There's a Best of San Diego thing that they do every year with one of the magazines down here. And we won Best Employment Law Firm and runner-up for Best Business and Estate Planning Law Firm. So that was fun.
Wow. That's huge, Sam.
We won Best Business and Estate Planning Law Firm last year. So somehow ended up runner-up in that one this year, but won the Employment Law Firm one this year. So it's pretty cool.
That's awesome. Well, I can definitely, from personal experience and using you guys to help write the employee handbook for Karma Rescue, you guys are definitely top notch on that service and fast.
Thank you.
Yeah, actually, we'll probably ask a question about employment law today. Okay, well, let's lead in. So I am so excited today, you guys. Oh, yes.
Can I share my win?
Of course.
Hi, everybody. I did a pitch competition at Entrepreneur Leadership Program, and I won first place. Wow. And the winnings was $2,500. So I'm so happy about that. So if you get a chance to do a pitch competition about your business, please, it'll sharpen your skills.
Man, Karen, congratulations. That is absolutely a well-deserved one too.
Thank you.
Very cool. Oh God, this is a good money week, you guys. I like the accomplishments that are money. This is good. I feel like I just made money too. This is so exciting. Good job, you guys. Okay, so now without further ado, my introduction cannot do this guy any justice. This is the topic of law this week, right? Nonprofit law and legalities and everything on the nonprofit sector side that has anything to do with law. So we have a special guest today, Sam from Better, who is an attorney, and he is a nonprofit tax exempt specialist. So his focus is everything in law and the legal world, but for nonprofits. So I thought it'd be really cool for us to have an opportunity to ask questions, you know, and he's going to hit on some hot topics kind of in the nonprofit sector too, things that we run into being a nonprofit organization and the maybe a little bit different nuances that we have to deal with as a nonprofit versus like a for-profit entity. So, Sam, I'm going to hand it off to you. Let me tell you one thing about this guy. He is funny as shit. When he emails me, tell me, does anyone else have an attorney that emails them memes? I doubt it. That guy like totally does, and it makes my day. Like I'm like, I may get charged for this email, but I want to do it because I know it's going to make me laugh. So it is like worth every single penny. So we're just really blessed to have you a part of the family, Sam, and I'm just excited for you to kind of bless us with some legal stuff today. I'm going to hand it off to you to maybe just touch on a couple of hot topics that you kind of think are really prevalent in the nonprofit industry now. And then I've got a couple of questions for you, but kind of maybe also just give us all like a little background on who you are and kind of how you got into nonprofit law, because that's such a like specific niche.
Yeah, for sure. Thanks for the glowing intro. And yes, I definitely send a lot of memes and GIFs in my emails. They convey the sentiment better than words sometimes. So it's just, you know, it works.
Yeah.
And yeah, so this is actually my second law firm. I've had 2 law firms that have both been designed to help nonprofit organizations, as well as small and medium-sized business and like creative freelancers and entrepreneurs. And before that, I was actually at a nonprofit organization in San Diego here where I'm based, called Invisible Children, which worked on stopping one of the longest running armed conflicts in Africa. And so that organization was an organization that I started at when I was still in my 20s. And I was actually at that point sort of pretty disillusioned by practicing law and didn't want to be an attorney anymore, and spent time at that organization and just saw a ton of other people my age doing things differently with their degrees instead of the, you know, standard path and trajectory that you always see. And it was just a game changer for me to recognize that I could use my law degree to help people, first of all, instead of being some kind of skeezer or try to like sue people and win and all of that. And so that was awesome. That was a great learning lesson. And then just being at that nonprofit and understanding the challenges of it and realizing how inaccessible law was and lawyers were for nonprofit organizations, really just sort of kind of galvanized me into wanting to do something to help. And so my business partner at the first law firm, she had been the general counsel at that nonprofit organization. And so we ran that law firm up until probably the end of 2019, early 2020. And then I launched Better on March 1st, 2020, of all the times to launch a business, and had planned on doing a couple in-person events every month, which obviously we did not do. And we're still hoping to get back to doing that. But we are really just geared towards catering to traditionally underserved areas of business or nonprofit, being accessible, being affordable, and really just trying to make it easy. We don't want to be that lawyer that comes in like a bull in China shop and breaks shit and just gets in the way and delays things. And so for us, it's really trying to be responsive and quick, like Sharon said, and really trying to put good work product out there and be a customer service business at the end of the day, instead of that 3-piece suit corner office bullshit that you get from most law firms. So that's kind of a little bit about us. Some of the kind of like hot topics that I'll mention, I'll cover them quickly and then we can dig into those deeper if needed. But one that keeps coming up for me this year in particular, for whatever reason, is paying someone commission to do fundraising. And specifically, that means commission based on how much they fundraise. And this is something that is permitted legally. It is not something that's illegal to do. You're absolutely allowed to do it. At least in California. I'm going to always be speaking from California since that's where I'm licensed. But in California, there are actually 3 types of professional fundraisers that you have to register with the state, which obviously then shows that it is permitted to be someone that is paid to do fundraising. And even those, they contemplate that commission-based pay based on how much money you raise. And so it's fascinating to me because it is legal, like I've said a couple of times, but it is very, very much frowned upon from an ethical standpoint in the academic and nonprofit world. And mainly because they don't want it to incentivize people to make more money if they bring in more fundraising dollars, because that incentivizes them to use maybe nefarious methods or, you know, leverage things that aren't necessarily going to be okay or legal, or, you know, try to get donations regardless of who that source is or what that money is for. And so the whole idea being that ethically, most nonprofits don't look kindly on paying some type of commission based on the amount of money that's fundraised. And just to draw a comparison real quick to for-profit companies, with for-profits, if you are looking to get people investors and make money off of whatever they invest, that is actually illegal. You have to be a broker dealer in order to do that with for-profits. So just to draw that comparison, yes, nonprofits typically have different rules and laws, but in this particular situation, you can see where it's illegal for for-profits and frowned upon for nonprofits, even though it's legal. And so this just has been coming up for me a lot. And essentially I walk my clients through the fact that it is legal. However, it is ethically frowned upon. And if, you know, you end up, the public knows that you hired a fundraiser and paid them commission, that could be a bad look from a PR standpoint. And so ultimately with all of my clients and whatever we're advising on, it's up to them at the end of the day, whether or not to take that risk. But that's something that's been coming up for me. Thought I would mention that one. Another one that comes up just all the time in California, has been for years now since our laws changed, is going to be AB5, the independent contractor classification law with the ABC test. You'll probably have heard of one of those, or AB 2257. That is the second law that was passed to sort of augment and sort of amend the AB5 law. And the gist of this is that there used to be 11 factors that you would use to determine whether or not someone was a contractor or an employee. It was pretty easy. If it was more factors than not weighing in favor of independent, then they were probably an independent contractor. And you really didn't have to worry about proving that up very much. Now, the new law changed it to be a 3-factor test, the ABC test. And the first factor is just kind of how much do you control them? Is it butts and seats, 9 to 5? Are you looking over their shoulder? Typically, that one weighs in favor of an independent contractor. It's not a hard one to satisfy, even with employees. A lot of the time, like the way I manage my employees, they can kind of do whatever they want. So it would be satisfied there. The second factor is always the one that's the problem, the B factor, which is whether or not they are crucial to what you do. And that's an oversimplification, but essentially, like, if I was going to hire a lawyer at my law firm, they have to be an employee because we are lawyers and we provide legal advice, and they would be client facing. That's a big piece of it as well. And so the B factor, that crucial to what you do, is the most difficult one to satisfy. The third one is just whether they do this for other people. So are you their only client or not? That one's usually pretty easy to satisfy. Now, the reason I bring this up is that we get the question very often that it doesn't apply to nonprofits, right? And it unfortunately does apply to nonprofits, just like it applies to everyone else. There are some exceptions for the creative industry, and there are exceptions sometimes for like business to business, but the law is kind of messy. And so to get down to whether one of those exceptions is applicable is a pretty like deep analysis. We typically spend a few hours with clients going through a spreadsheet that they fill out, going through those roles, and then basically giving them like the risk profile of whether or not that person should be an employee or a contractor. And again, ultimately, it's up to them whether or not they make those folks employees or leave them as contractors. We did have an arts organization recently basically ignore our advice when we said that everyone needed to be employees, and they have since been audited and gotten hit with a few penalties because those people should have been employees. So definitely something to mention. I used to tell people that the chance of getting audited on that classification of contractor employee was not high, but it seems to have shifted that they're sort of randomly auditing people now. And so it's not as unlikely anymore that you might get audited. So more important to try to pay attention to that compliance. And again, definitely applies to nonprofits, unfortunately. And then another one that I'll bring up, and then I'll get into like my favorite one of the 4 things that I wrote down to talk about. So another one is what's called a commercial co-venturer. So when I mentioned raising money and being paid to do that earlier, a commercial co-venturer is a type of fundraiser that you have to register in the state of California to be. It applies to for-profits, but the reason it's related to nonprofits is this is those scenarios where, and you guys have all seen this, the original campaign that I heard about it, and I think it might have been the first one ever, was the RED campaign that they did back in the day, where any product sold by, like, I think Nike that had the RED branding on it benefited some cause, and they advertised that too. And so with that made Nike or whoever was selling those products the commercial co-venturer. And so what ends up happening in that scenario is somebody sells products or services, a portion of the proceeds from those sales go back to a nonprofit organization, and they advertise to the public that happens, which is kind of how they increase their sales, is by saying, hey, look, when you buy this, it does good. And that makes them a co-venturer. They have to register with the state. They have to file an annual report laying out how much money they made, how much they donated, who they donated it to. And the really interesting aspect of this is that a nonprofit organization does not have to do any registration or compliance for this. They just report those donations like they normally would with their taxes. But the unique aspect of this is that if a company wants to avoid registering, they can actually have an agreement in place with the nonprofit that they're going to donate to. It has to have a few like special things in it, things about like when the donations are going to be distributed, things like that. But if they have that agreement in place, they actually don't have to do that registration with the state. So it allows them to save a few $100, a filing requirement, all of the above. And that's just one that I see way more often than not, that people just sort of, and it's well-intentioned, they go out, hey, I'm going to sell these products and donate to this nonprofit. They have no idea that there's registration required. They have no idea that they need to have an agreement in place. And it's one of those things that you don't want to be working with a partner and then them get hit with some type of penalty and get in trouble, because you don't know if that means they're going to try to pull back some of the donations, or who knows what's going to happen there. So just something that I mentioned to be helpful for nonprofits that get approached, for people that want to do that, so that they can help them be compliant in that scheme. And then the last one, so I was just telling Sharon, actually, I was at the 1% for the Planet Summit in New York City, which is the global organization where you can be a business member if you donate 1% of your profits. And then they have nonprofit members that you donate to, and it's all sort of environmentally focused. And at that, Patagonia is a big force in that group, because they're obviously, you know, all of the things. And they're a B Corp as well, and my law firm is as well. And one of the seminars that I went to, they explained this new model of ownership that is really fascinating, and I think has some applications in the work that I do, because essentially what they did is they took all of the owners and investors and the founders of Patagonia, and they created a trust. It's called a perpetual purpose trust. And California doesn't have these, so I'll circle back to that in a second, because that blows my mind. But it is essentially like a charitable trust. And they took all of the voting rights and they put that into the trust. Then they took all of the profit rights, all the dividends from Patagonia, and they put that into a 501c4. And so what they do now is the 501c4 donates and uses all of those profits to do good in the world and to fund different political campaigns and different environmental campaigns. And then the trust is there and has specific trust purposes that require it to be something that is good for the planet and is good for people and community. And so it essentially separated the ownership from the profit and the decision-making from the profit. And this is actually a movement that's going on in Europe that's getting pretty big, called steward ownership. And I think it's fascinating in application for hybrid models. So I get a lot of questions from clients to have like a for-profit and then a nonprofit that in some way, like, let's say it's a therapy practice and they want to subsidize their therapy rates so people can afford it more. Or, you know, I had a call today with a company that does markets all over the country, and they want to subsidize and give scholarships to the small businesses that would pay to have a booth at the market. And so in those scenarios, there's a nonprofit and a for-profit that have to work together. And that can get really complicated, because there can be conflicts of interest. There can be all kinds of things that make it a little bit wonky. And so this perpetual purpose trust, I really think there's a lot of opportunity for there to be situations where a trust could own both the nonprofit and the for-profit, make them work together, limit a lot of those conflicts of interest, and really just undo this kind of capitalist bullshit that we deal with every day. And this just sort of, you know, 1000% salary versus the CEO to the furthest down the line of the staff and all of that. So that was something that's got my gears turning. It's something that I'm thinking a lot about after that summit. And I think has a lot of applications. And what I'm going to probably start working on here in California soon is trying to get legislation passed that allows for the perpetual purpose trust in California.
That's fascinating. Okay. So while all of that is wild and mind blowing, I already know, Amber, you're probably over there going like, what the fuck right now? What I want to know, if you can expand more on, because you actually reminded me that it is a hot topic, the one about the commission and people fundraising on behalf. And then, you know, all these nonprofits want to have grant writers, but not pay them and then give them % if they get a grant. And can you kind of just retouch on that topic again? And maybe if there's some more specific details or even some examples that you can give that some of us may relate to.
Yeah. So one of the things that I always highlight here is it's useful as a model to look at the California registration scheme, because we know that those roles are allowed and that they're legal. And so the main three that we have in California, the first one's going to be a commercial fundraiser. And this is essentially going to be what we're talking about right now, which is where you pay someone to go out and raise money for the organization, and they, can do it in any number of ways, and then they can get paid, whether it be commission or not, or a flat fee. Then there's going to be fundraising councils. They're less public facing. They actually look more at helping the nonprofit organization craft their campaign and all of their materials, and how they're going to solicit the donations and all of the above. And then there is the commercial co-venture, which is the one that sells products or services and donates. And so with all of these, like the fundraising council, that one's less likely to be one where they're going to be paid a commission because they're helping to basically create the materials, versus actually being out there and raising the money and finding the donors. And same with the commercial co-venture, they're selling products and just donating a percentage. So it's that commercial fundraiser really that we're focusing on here. And with that, I think if you had a grant writer that's like in-house, they're less going to be considered that commercial fundraiser because they're one of your employees. And even then, paying them a commission is still one of those things that from an ethical kind of standpoint is pretty frowned upon. And I'm going to look up real quick. There's an organization that sets out like ethical standards for nonprofit organizations, and I'm forgetting the name of it because they're the ones that sort of lead the way with this sort of frowning upon it. And yeah, I mean, a grant writer, though, is an example. If they're an outside grant writer or an outside grant writing company, they would probably be considered that commercial fundraiser. And even with those registration forms with California, they include that you can be paid a commission based, a percentage based on the fundraising amounts that you come through with. And and so the reason that it's frowned upon, I guess, like, it's sometimes hard to like outline the specifics as to why it's frowned upon, but the idea is that it generally incentivizes people to raise money in ways that are going to benefit them. And so it's less about raising money for the organization and doing it for the right reasons and raising that money specifically for the organization, because they will make money off of how much they raise. And so the idea is that in doing so, they might take shortcuts. They might, lean on people to donate more. They might do different things that just are less than ideal from a PR standpoint or from a legal standpoint to make sure that they're getting those donations in, because then it benefits them if they receive a percentage of it. And so the other difficulty there, like Dr. Sharon just put into the chat, is that if you get a restricted donation, you can't actually pay them any commission out of that because that money is legally restricted to the purpose that the donor restricted it to. And so there are just those types of complications that come into it as well. Not to mention, like, let's go back to the grant writer that's an employee. If you have a grant writer that's an employee and you pay them that commission, that's most likely going to be a specific type of bonus, and it's going to be most likely a non-discretionary bonus. And typically with non-discretionary bonuses, they're taxed really heavily. So that person's also not even going to get the full bang for their buck on that amount of money because of how heavily it's taxed. Plus, it can sometimes turn if that person's an hourly worker, that compensation can push them over the top into overtime. And then you're paying another rate on top of that. And so it can be really costly. And the real danger there isn't necessarily that it's higher taxes and more costly. It's that if you do that wrong, you could then be facing some legal complications later because of a compliance audit or something like that, because it was done incorrectly. And then, similarly for an outside party, if you're paying them that commission-based amount, again, the restricted donations, that limits it. But in addition to that, it's just going to be a situation where the law looks at that and allows it. But these different organizations and these different ethical groups say you're incentivizing people to make money for themselves, and that just inherently means that there's room for abuse. And yeah, the Grant Professionals Associate Code of Ethics, that's definitely one of them. And then there's another one I'm going to find, because there's definitely a few, the National Council of Nonprofits, which is one of the like leading authorities out there, and they certainly frown upon it as well.
Yeah, this seems to be like an ongoing topic all the time. I really run into it just with nonprofits that, they don't have funding to pay for grant writers. So they're trying to find a loophole, which is totally understandable. It's just not really within guidelines. So it's, it's kind of one of those battles that people have to face. And so some of these are really great questions. Any other questions on this topic from anybody or anything that anyone needs clarity? Because I'm going to move it on to another topic I'm dying to know some more about. But any other questions on wanting more clarity on grant writers and donors and fundraisers? Okay. This is really good info. Okay, so my next question before I open it up to the group is the next hot topic that a lot of clients have been asking about, and because we actually had a lunch and learn on it a couple weeks ago, is on auctions and the legalities around auctions, raffles, sweepstakes, the difference between them. What do we need to worry about? What do we not need to worry about? We have a current group we work with now that's about to do an auction and a raffle, and they're nervous because it's hard to find clear information on what kind of legalities do we need to have, or what type of reporting do we need to have for those.
Yeah, so auctions, the first thing to always say is that every state has different rules, so always pay attention to whichever state you're doing whatever it is in. But auctions tend to be pretty easy to do, actually. They're not going to be as difficult to operate as like a raffle or a sweepstakes. And so raffles and sweepstakes, those have their own challenges because you have to make sure with those that they don't turn into a lottery, because if they turn into a lottery, that's illegal because only the state and the government can do lotteries. And so the kind of general gist there is that when you do a raffle or a sweepstakes, it just has to come down to whether it's random chance or skill. And it cannot be both. And that's usually what you're dealing with there. And those actually require registration. If you do a raffle as a nonprofit organization, you have to register here in California with the Attorney General's Office, Registry of Charitable Trusts, with the details about that raffle. And you have to follow up with reporting on that raffle and all of the above. But with auctions, the main thing that you have to pay attention to, because there is no registration requirement here in California for an auction, but you do have to make sure that the tax pieces of it are sorted out. Because with an auction, whatever that money is that someone, donates or bids on the auction item, you have to offset the value of the auction item that they win. So for instance, like the common example that's used is, if let's say you auction off tickets to your gala, 2 tickets to the gala, it's $200, and the tickets are normally $100 a person. Let's say the dinner at the gala is worth $50 per person. So of that $200, then only 100 of it is what they can write off as a charitable deduction, because you have to offset the value of what they're receiving. And so similarly, like baseball tickets, if it's the World Series is starting this weekend, and if you had tickets that someone bid $1,000 on and the tickets were worth $500 each, they can't write that off, because if they bought 2 tickets for $500 and they bid $1,000, that's the value of the ticket. So there's actually no donation amount that they get to write off there. The good thing for a nonprofit organization is that they probably had those tickets donated, so it's still $1,000 that goes into the bank for the nonprofit.
One of the questions that we have in the chat is, can my nonprofit host a raffle and note the drawing will take place once a certain amount of dollars has been raised?
Yeah, that's totally fine. You just have to make sure that with that, you make the rules abundantly clear that that is how it will work, because that is one of the really big things with like raffles, contests, sweepstakes, is making sure that the rules are exceedingly clear, describe how it works, how the winners are selected, what the value of the prizes are, when people will be notified whether they won or not, whether purchase is necessary to enter, all of those types of things. So yeah, that's something that you should be able to do. I've never heard of that being prohibited, but you would want to make sure that the rules are very clear and that the rules are readily available wherever anybody is going to enter and wherever you're advertising the raffle.
Okay, perfect. That definitely clears things up. I think where a lot of people were getting confused with the auction or whether they're doing the raffle is how to report that. So basically you're reporting if the amount goes over the actual value, then that's the portion that the donor gets to take as the contribution. And then, but the whole organization gets that full amount. So what does it look like in the nonprofits reporting?
Yeah, so you're just going to report it essentially like any other type of influx of funds. So typically with your $9.90 and then the $199 in California, they're going to have you break it down. Was this a raffle or an auction or mail solicitation or in-person donation, whatever that looks like. And so typically you just work with your CPA to make sure that that gets put into the correct category, the subcategory, I guess, because overall it's going to fall into your gross receipts and it's going to be considered a donation. And then, it's also up to that CPA to kind of be on top of, or your accounting department to be on top of the, amounts that you're offsetting, because typically you're going to want to put that in the donation receipt for folks that they have to offset X amount versus their donation.
Right. Okay. That totally makes sense. Okay. I have a couple other questions that I'll fill in, but does anybody have any questions that they want to ask while we've got Sam on here specific to nonprofit legalities? I have another question though, if somebody doesn't have one and doesn't.
Looks like we just got another one through the chat that I can answer. So the question is, what if a nonprofit wants to charge for services or make money from an online paid course like Udemy or Coursera or YouTube? And so this one gets kind of tricky because you can do it. The most important thing to pay attention to is whether or not it is in line with your charitable purpose. So let's say, for instance, you have an organization that teaches people entrepreneurial skills, and you then have a course online that teaches them that, like tells them how to start their business and market their products, whatever the content is. Usually that is going to be considered in line with your charitable purpose, and you're going to be allowed to do it. The thing that you have to be careful of and that you have to make sure you're not dealing with is what's called unrelated business income tax, and UBIT for short. So UBIT is where a nonprofit organization does something that is an unrelated business function, and they then have income from that that's taxed just like they're a normal business. And so that's something that's allowed. Nonprofits can absolutely do business type functions, sell things or services, and make money off of that. They will be taxed like a normal business, though. So it's not the same tax exemption that you get from things that are aligned with your charitable purpose. And the danger with UBIT is that if the amount of revenue that you get, that unrelated business income, outweighs the amount of money that you bring in from donations and grants and just the public fundraising at large, then you could lose your tax exemption because you're operating more like a business. So what I always tell people is, if you're going to have UBIT, try to keep that to 40% of your overall operating budget, and then 60% for donations and all the public funding. And then that should keep you safe with UBIT. Now, the other thing to pay attention to, though, here with this question is that it's not always easy to figure out whether or not something is in line with your charitable purpose. The question that I get most often on this is, can I sell merchandise? And is that going to be something that falls in line with my charitable purpose? And the answer is typically no. That's typically going to generate UBIT because you're just selling merchandise that, other than having your logo or a slogan on and raising money for the organization, does not relate to your charitable purpose. The example that I provide that helps drive this point home is that if you were selling merchandise that was developed by the beneficiaries of your organization in them learning about being an entrepreneur or a craftsman or an artisan, that absolutely falls within your charitable purpose, because you have created these classes that teaches these people how to make these products, and then you sell them to support the organization that continues that cycle of teaching these people how to be entrepreneurs and craftsmen. So that one would not trigger UBIT, because the beneficiaries of the program and the program itself is what's producing the merchandise that's being sold, as opposed to just going on, like one of the, Shopify and selling t-shirts that are just, white label blank t-shirts. That's typically going to be UBIT because it's so unrelated to the purpose of the organization. So kind of a, it depends answer. I know, I'm sorry, that's the curse of being a lawyer, but it is something that you can do. And you can even do it if it's unrelated to your purpose, so long as that doesn't generate more income than your donation income is. Yeah. And then, not sure I'm tracking on Steven's question. And given that it's Texas law, I probably can't advise on that anyway. I guess just from the question as it stands, I would say you would want to do them differently based on the states in which you're doing them. So I would separate it and do it according to whatever Texas's laws are in Texas, solicit it to Texas people, and then separately, like, do it in other states specific to their rules and target it to them, because that is a very real risk, is that one state's rules might be a little different than the other, and you might be complying in one state but not another with that raffle or contest or giveaway. And also too, like giveaway and raffle and giveaway and contest and giveaway and sweepstakes could all probably be interchangeable. It just depends on the nuts and bolts of what the actual thing looks like. And again, you know, it comes down to like contests. All right, contests and sweepstakes are the ones we advise on most frequently. And with a contest, there has to be skill involved, and that's how you choose the winner. And with a sweepstakes, it's random. There has to be like a random number generator that chooses the winner, and that's the big difference. And again, if you have, and there has to be no purchase necessary for the sweepstakes, because if there's purchase and chance, it's a lottery, and you can't do that.
Can you reiterate and go over one more time the unrelated business expense, and using because the most common example is a lot of nonprofits love to create t-shirts, sweatshirts, mugs, or whatever, and put them online to sell them to bring in more revenue for the organization. Can you go over that example one more time for us and just sort of reiterate how that's legal, how about that is okay, what not to do, what to avoid, or just what to be aware of?
Yeah, and there's a distinction there too with like the question that was asked about like having online courses. Online courses that are in line with your charitable purpose, especially if it's an education nonprofit, are much more likely to be okay and not trigger UBIT. But with the merchandise, yeah, the big distinction to draw is if you just go and create some merchandise and sell it, even though that fundraises for the nonprofit organization, that doesn't make it part of the charitable purpose. Unless, you know, like your charitable purpose is making sustainable clothing, and even still we're going to be pushing it there. But the distinction to clarify is, if you're just selling products or services and they're unrelated to your purpose, almost certainly is going to trigger UBIT, and you're going to have to pay taxes on that. And that's when you have to make sure that it doesn't raise to the level that it's more money than you bring in from donations and grants and sponsorships, things like that. But if you have part of your organization is designed to essentially like train people to make the merchandise or the products, or train people to provide the services, well, then by selling those products or providing those services, because you've trained those people to make them or do those services, and then you're lifting them up by helping them sell those services, that's usually not going to trigger UBIT because it's part of your programming. And the best example again is like, and I use this from the nonprofit organization that I was at, Invisible Children, that I mentioned. We sold messenger bags and bracelets and clothing and all kinds of stuff like that. And it was literally made by hand by people on the ground in Uganda, that we like essentially created those programs that taught them how to make those products. And because of that, that does not trigger UBIT because it's all a part of our charitable programming. And then by selling them, and that money going back to those beneficiaries and to fund those educational programs, it's all part of the charitable purpose.
Wow. Okay, that's awesome. I know that comes up a lot with a lot of our organizations. Yes, Amber.
So what would be your recommendation from a creative standpoint to do in lieu of that? Or what have you seen other charities do for fundraising purposes that wouldn't trigger it? Or any ideas?
Yeah, I mean, one of them that I actually touched on before is going to be that commercial co-venturer. So if you got in line with someone that already makes products, and then you just give them a license to your branding and your trademarks and things like that to then put it on their products, and then go sell those products and donate a portion of the proceeds back to you, that's going to take it completely off your hands. And, you know, you can get an agreement in place with them, or they can register and, you know, do that way. And that's not, you know, that difficult. We actually, as a for-profit law firm during the pandemic, at one point in time, we basically told all of our clientele, and we advertised this and we did the registration with the state, that anybody that signs up with us to work on like website policies, click wrap agreements, you know, any type of online kind of facing legal project, we would donate a portion of the proceeds to a nonprofit organization. And so we've done it. It's not that difficult, but that's an excellent way to kind of like avoid that situation yourself as a nonprofit. Okay,
so let me push this even further. So without knowing that I was doing this in my nonprofit, we're doing it. But I know we don't have the formalities around it. So example, dance competition sells that's not associated with me at all, sells my shirts for Dancers Against Cancer. They then donate the proceeds to us, right? Do we have to have a formal agreement, or is there something in the minutes that defines this relationship? Or is this some type of formal document that we would come to you to create for these different relationships?
Yeah, I mean, I would recommend having an agreement in place with them for two reasons, really. One is that it helps to establish their compliance. And then number two, it helps you to protect your brand, right? And your logos and your trademarks and all of those things, because in an agreement like that, a licensing agreement that has the commercial co-venture language in it, you can put parameters around how they use your brand. And that's really important because, you know, I've seen clients that come to us and they created some art and then all of a sudden it's on like bus benches and billboards, right? And they didn't want that. They never thought that that would be what their content would be used for. And so that's one thing that I think just is very helpful to protect yourself. The other thing to mention too that I haven't said yet is that with those commercial co-venturers, if they do not advertise to the public that they donate the proceeds, it's no longer a commercial co-venture. That is the linchpin there for whether or not they become that type of co-venture that has to register. If they're just selling the products and donating to you behind the scenes, no need to register. That's all good. That's just kind of what a lot of businesses do, generally speaking. I would still recommend having an agreement in place with them because there's other things that can come up. Like, let's say the relationship sours and they've got 10,000 more shirts and they're going to go keep selling those for 10 years to come with your branding on it. That's probably not something you'd be happy about. And without an agreement in place, it's going to be a lot more difficult to stop them from doing that. So things just, you know, agreements are always there for the worst case. Unfortunately, we're like insurance salesmen almost, because we have to plan for those worst case scenarios and put things in place that cost you money. But I would recommend having some type of licensing agreement, commercial co-venture agreement in place for that relationship for sure.
Sam, how small world is this? Does this look familiar?
That does look familiar. Falling Whistles. That's hilarious. So Falling Whistles is an organization that kind of grew out of Invisible Children in some ways. Same kind of region in Africa. That's crazy. That's so funny.
Right? How random was that?
That's so funny. I love that. Yeah, Falling Whistles, I don't think they're still around. Invisible Children is still around, but they're a lobbying organization in DC now, so they're a lot different.
Okay. Ooh, Alex, good question. Speaking of trademarks, should all nonprofits have this? And what's your feeling? Kind of expand on that too. Like, should nonprofits have trademarks? Is it worth it? Because it can be expensive. And when should or should not they get into trademarking?
Yeah, so I would say that I think that nonprofits should have trademarks if they have something that's strong enough to trademark. There's a whole bunch that goes into trademark. The two like threshold sort of criteria for a trademark is whether or not it's confusingly similar to another trademark or whether or not it's too descriptive of whatever the products or services are. And so assuming that those two things are not an issue, then I would say that, yeah, most often I would recommend that a nonprofit have trademarks if the budget's there, because it's not cheap, unfortunately, to get a trademark registration. It also takes almost a year these days to get it, so it's a long runway. However, one of the like most overlooked and I think least recognized ways to raise money for a nonprofit organization is licensing its brand and its intellectual property. It is, if you have strong branding and you have good content and intellectual property and licensing that, it's one of the like, honestly, one of the best and, like I said, overlooked ways for a nonprofit to raise money, because you can license that out for products like we've been talking about, for, you know, joint events, whatever it is. If you have content actually that you make, like curriculum and things like that, licensing that out and having people pay you a royalty or some type of licensing fees for that, it doesn't trigger UBIT because it's your brand and someone else is using it. So it's a fantastic way to raise money for a nonprofit organization that's also pretty passive. So I always like it for that. And if you have a trademark, that allows you to feel a lot safer when you're doing these licensing relationships, because there is horror stories in the law of licensing a trademark to someone and then who got that license, essentially like usurping that and taking over the trademark and taking it from who licensed it. But if you have a trademark registration with USPTO, that ain't happening. You have a federal government authorized registration showing you that own that. And so I think trademarks are great for that reason. It's always important to highlight, though, that you are not legally required to have a trademark. You can certainly do work out there without trademarking your brand name or your slogan or your logo. that's totally fine. And you actually already have what are called common law rights in your geographic reach. So once you use a trademark with your products or services, you have what are called the common law rights to those in however far your reach is, which that's a whole debate in the legal academia world right now, is like, with how businesses are online, does your reach extend to everywhere that your business touches through the internet? Because then that kind of makes an argument that your trademark reaches really far, when traditionally common law rights were like, you know, wherever your brick and mortar is in your local area. But common law rights are also not as strong. That's why there's the registration, that they don't give you exclusive rights. They're not in all of the states of the country, all of the above. So long way to answer the question. I think that nonprofits should have it if, you know, none of the hurdles of descriptiveness or similarity are there. And then I think that that creates a great foundation to then have licensing to raise money, and doing different things like that, and the commercial co-venture stuff we talked about.
Right. Okay. Any other questions from the group? I got a question. Okay, I'll ask the group again in a minute. My question comes to one that comes up from clients a lot, is that they are getting into partnerships with other nonprofits or other for-profits or with schools and things like that. What do they need to be aware of when getting into a partnership? Should they have, because I know we've talked about MOUs and whether they're really impactful or not. Should an organization have a memorandum of understanding? Should they have a partnership? Should they have a contract? What should they do? And then Heidi, I'll get to your question. What should they do to mitigate any kind of risk when going into a collaboration or a partnership?
Yeah, so I'm always like, I always kind of tell people that MOU, contract, like, I don't put a lot of stock into the name of the document so long as it's legally binding. And a lot of the time MOUs aren't. And to me, an MOU that's not legally binding is a waste of the money that was spent to draft it. Because if you're putting something on paper, yeah, it might set out expectations, but if there's no legal backing to it, what's the point of that? And so I'm good with an MOU if it's legally binding. I prefer a contract in all of the scenarios that you brought up. And what I would say is that, you know, the most important things to pay attention to are going to be making sure that whatever is going on in that partnership, that collaboration, that whatever the partner is doing isn't going to jeopardize your tax exemption. So making sure that whatever they do is still in line with your charitable purpose as far as it relates to what you're doing with them. The other thing is going to be stuff that we've talked about, which is making sure that your brand is protected and your trademarks and any of your intellectual property is protected in that relationship, so they can't take it and run with it or take it and put it on, like, you know, porn or who knows, whatever is going to be not good for your organization. You need to have those parameters around that. And then just a lot of the things that are going to be logistical. So, you know, how does payment work? What happens if payment's not received on time? How do you get out of the agreement if something goes wrong? You know, some of those types of things that get overlooked because people just say, oh, well, we had a great conversation, I trust them. And we trust everyone until we don't. And so it's very important to have that stuff in there. And then I will say, like, specifically on the note of schools, it sucks contracting with schools and government entities because they have essentially immunity. They have, it's not full immunity, but governmental immunity is pretty broad. And so that causes two different things. One, in the contract negotiations, they aren't going to budge on shit because they don't have to. And in fact, they're legally like prevented from budging on things. And so you're going to have a contract that's not as favorable to you. And then if something does come up, they're probably immune and it probably doesn't matter because they have that ability to just say, well, we're a government and you can't sue us for that. And so it's not fun to contract with schools and government agencies because of that. But generally speaking, like, make sure your brand is okay, protected in the agreement, make sure that you have parameters around what they're doing so that they don't jeopardize your exemption. And then if I had to add another one, I would probably just say making sure that they're not doing anything that's going to cast a negative light on your organization. Because when you're working with someone, if they go out, you know, think about Kanye, when everyone started to try to drop Adidas because Kanye was going off the rails. That kind of stuff can affect you, even though it's by second or third degree. So sometimes including some, like, you know, moral guidelines or like parameters in an agreement about how someone behaves publicly if you have a very public facing organization.
That's solid. That's good. Okay, Heidi, I know you've got a question.
Hi, and I'm hoping this isn't too specific of a question that other people can't benefit from at some point, but we have a very young organization. My husband and I started it as co-founders. We have purchased 2 pieces of property. We're not wealthy people. We built a small little cabin on this 2-acre parcel, less than 400 square foot cabin that we live in. And we very much want to build a barn for our program and on the property. And so we're actively, we're beginning to raise money for that barn. And we also own another small house half-mile away that we are also renovating and using some donation money for, again, for our program. But we own the land, we own the buildings, and it's been advised to us that we hold on to it so we can maintain control, especially in this early stages, and then have a living trust that puts the properties into to the nonprofit in the living trust, so that donors know that yes, we control it now, but at our passing, it would go over to the nonprofit. And that we separate ourselves liability wise by having more of a tenant landlord relationship and having a long-term lease for the use of the properties. I was just wondering if you had anything to add to that.
Yeah, I mean, I think it's a good recommendation. We do estate planning for our clients, so we do wills and trusts. And one of the biggest benefits of a living trust, like you mentioned, is that it allows you to kind of protect what's in it during your lifetime, and then also dictate how it's going to be distributed when you pass. And so I think that, that it checks those boxes for you. It protects that property while you're alive. It allows you to distribute it to the nonprofit specifically and directly, probably with some tax advantages when you pass. And then the benefit of doing it that way also allows you, like you said, to treat it as a landlord-tenant relationship, because you can treat the trust as the landlord and then the organization as the tenant. And then that way the tenant essentially pays rent to the trust to use that barn or that location or that land. And then that does sort of provide an additional buffer of liability. It's tough in those scenarios because, if you were on site during an event that liability arose out of, and you're the settler of the trust and also part of the nonprofit organization, and kind of involved at all of the different stages, I could see an attorney still trying to hold you personally liable for all of that. Now, whether or not they would succeed, that comes down to the language of the trust and how good the paperwork is on the landlord tenant side of all of it. But that is the general idea of what you've been counseled on, is to create the trust as the landlord, put all the property in that allows the distribution upon your passing and also protection while you're alive. And then also helps to provide that additional separation that should help to protect you for any liability that comes up from using that barn or those locations.
And does it also help so that we can use parts of that barn for our personal use?
Yeah, totally. Because then
without there being some weird ethical issue.
Yeah, totally. Because you, as the settler or the grantor or the trustee, there's different language you can use for that when it's your trust. You can still use all of the assets that are in your trust because it's yours and they're still yours by second degree. And so you would just need to make sure to build into the rental agreement with the organization that, landlord takes priority if there's a priority date that the landlord wants to use it for X, Y, and Z. And then that way you just treat it as an arm's length, like landlord-tenant relationship. And so that's pretty common for landlords to say, look, we get the veto power because it's ours and we want to use it sometimes. So that makes sense. You could definitely do that.
And what about from an ethical standpoint for donors to be donating money to build a barn on land that we own?
It's something you'll definitely have to address with them. And I think it's going to come down to whether or not donors are okay with that. And I think for
so
you,
it's a trust issue.
Yeah,
it becomes
totally.
a trust issue of how much integrity we have and how much they believe that we really are doing what we're doing.
Yeah, and I mean, look, you could even show them the language of the trust that says that it's going to be distributed to the nonprofit later on when you pass, and that could be a trust builder for them. Now, of course, you could always change the trust later after they donate the money, and you could change it to where it doesn't go to the nonprofit organization. But yeah, I think primarily that's a trust thing, and you're going to have to do some explaining because people are going to wonder why you're fundraising to build a barn that is yours but
Right.
the organization can use. And that's definitely something that I would run through with your CPA too, because there's going to be some fancy footwork on your tax reporting for that, because that benefit is going to go to you technically while you're alive. And so most likely, like at the board level, you would need to have a board vote on using those funds to build that barn that isn't owned by the organization. And you wouldn't be able to vote on that because you're the one that's interested in benefiting from that.
Mm-hmm. Okay. Thank you very much.
Yeah, it's a good question.
And actually, Heidi, that is relevant. We have a couple of clients we work with that do things
good.
on their property or, have shared space and things like that. So, that was an excellent question.
Good, good.
Oh my God,
Comes
you
up a lot.
guys. Like, as usual, this hour goes by way too freaking fast. And I have like thousands of more questions. And so, Sam, like, we're so honored to have you. I can't thank you enough. This has been like one of the coolest lunch and learns ever. Amber and I were sitting over here like, are you mind blown? Because I'm mind blown. Like, sharp as shit. We really appreciate you. I'm sure people have other questions. If anybody wants to get in contact with Sam and his firm, I put the link to his website in the chat box. Sam Zao, attorney. The website is inbetterwetrust.com. Definitely reach out to him. He'll ensure that, especially if you're California, if you're not California, reach out to us, let us know. We'll try and find, a position for you within a different state. But if you're California, Sam is definitely your guy and clearly goes way beyond even just being a nonprofit expert. Their office handles so many other things. We've had tons of clients use them for various stuff, and I bring some of the weirdest questions, and he has handled all of them. So I thank everyone so much for coming today. Have a fantastic Wednesday and rest of your week. We'll see you all at next week's Lunch and Learn, 1 p.m. Pacific, 4 p.m. Eastern. That's it. Go have fun today, everybody. Thank you so much.
Thanks for having me. Thanks,
Thank you, Sam. I owe you.
everyone. All good. Talk to you guys soon.
Bye. Have a great day.
See ya.
Oh my God. Yeah, it just takes me. Was that Wild with a Whistle?
That's so funny.
This is my
You've had that thing for a while.
And Sam.
Hello.
You
Yeah,
might,
I bought that from Falling Whistles. Because they used to have an office over in Venice.
yeah, that's right.
Yeah.
I remember that.